I'm Aurora Bella Austriaco, Treasurer of the Chicago Bar Association, and welcome to the Chicago Bar Association's Justice and Law Weekly. I'm excited to introduce our honored guest who has traveled thousands of miles to join us here today. The Honorable Robert Shenton French is Australia's Chief Justice of the High Court. In Australia, Chief Justice French is the equivalent of our U.S. Supreme Court Justice John Roberts. Chief Justice French began his term in September of 2008 and is the 12th Chief Justice of Australia. He has been a vocal advocate for the rights of Indigenous Australians and has written extensively on the subject. Thank you for joining us, Chief Justice French. We are thrilled you are here with us today.
It's a delight to be here. It's my first visit to Chicago, and the city is quite overwhelming.
Well, I'm so glad. I hope you have had the opportunity to go around and enjoy the city of Chicago.
Certainly have.
Great, thank you, and thank you so much for being here. Justice French, most of our viewers don't really understand Australia or the history of Australia. Can you give us a little background in terms of what the history is of Australia, you know, what it's like, how is it similar or different from Chicago or the U.S.?
Well, really, Australia was first, of course, has a long, I often say Australia has a set of histories. There are the indigenous people who were there for 40 or 60,000 years, and then the next history is that of the British colonisers, and they came in the 18th century, around about the time the American colonies were getting a bit uppity about taking prisoners from Britain. Indeed, in 1788, when the British Crown first claimed New South Wales, that was the same year that the 13 American colonies were signing up to each other. And eventually the way that Australia evolved was into a group of 6 self-governing colonies. There's New South Wales and Queensland and Victoria and Tasmania, South Australia, and my home state of Western Australia. And those colonies got together at the end of the 19th century, and they agreed upon a constitution, and that constitution was passed as an act of the British Parliament, so it's different from your constitution.
Right.
And the Australian Federation came into existence on the 1st of January 1901. So we have not a revolutionary history, but an evolutionary history in that sense.
Right. You know, the U.S. government has 3 branches of government. We have the executive, legislature, and the judiciary. Can you briefly describe Australia's government structure?
Yeah, well, you have, that's reflected in Article 1, Article 2, and Article 3 of your constitution. And in our constitution, we have Chapter 1, which is the legislature, sets up the parliament as the lawmaking power. Chapter 2 is the executive, just like your Article 2. And Chapter 3 is the judiciary. And we observe a fairly strict separation of powers between the judiciary and the legislature and the executive.
Right, so it's pretty much similar to what we've got here in the United States in terms of structure.
But we have a different model, of course, of responsible government. So whereas your president is not part of the legislature, all our ministers, including the Prime Minister, have to be members of the Parliament, and they're accountable in the Parliament. They can be questioned by legislators, and if they want to introduce legislation, they bring it into the Parliament as members of the Parliament.
Great, fascinating. You know, you can tell the difference between the U.S. and the Australian system. Let's talk more in detail about the legal system in Australia. How is it organized? What is its structure? You know, how are appeals handled?
Yeah. Each of those colonies which I mentioned, which became states, had their own court systems, and those court systems were continued. And now you'll find in each state of Australia there's a state Supreme Court, there's an intermediate court, usually called a district or county court, and then there's a magistrates court which deals with the minor offences. And we've got some specialty courts, but there's a separate state court system, and we have 2 self-governing territories, the Northern Territory and the Australian Capital Territory, where our capital is, and they also have Supreme Courts and magistrates courts. And then at the federal level, we have a National Federal Court, which I was a member of for 22 years before I was appointed as Chief Justice. We have a Federal Magistrates Court, and we also have another National Federal Court, which is a family court, which deals specifically with family law matters. Right.
How many states are there?
6.
Oh, okay.
And plus 2 self-governing territories.
Right.
Which is the Northern Territory, and so those self-governing territories each has its own parliament, but they are not full states, so they're subject to the legislative power of the Commonwealth Parliament. And That's been used, for example, when the Northern Territory wanted to bring in a law about euthanasia.
Mm-hmm.
It was overturned by a law of the Commonwealth Parliament because it was politically contentious. Similarly, when the Australian Capital Territory tried to bring in a law about same-sex marriages,
Right.
the first version of that was overturned by the Commonwealth Parliament.
Right, right, right. You know, we were actually just chatting a little bit about, you know, how a case actually goes to the High Court.
Yes.
How it goes before you. Could you tell us, so that everybody can understand exactly how a case is heard? Does it go to the appeals court, and then it goes to you, or, you know, can it go straight to the High Court?
Well, the High Court has two kinds of jurisdiction. There's appeal jurisdiction and there's a regional jurisdiction. Now, the appeal jurisdiction leads to the High Court being, if you like, the final court of appeal for every court in Australia. So a case goes through the state system, and the final court of appeal in the state may make a decision. And then somebody wants to go further, they want to go to the High Court. Right. To do that, they have to get special leave to appeal to the High Court. So it's a bit like your cert process. Right. But we often have oral hearings for special leave applications. And the criteria for the grant of special leave is that the matter is one of great public importance or raises serious questions concerning the administration of justice. Right. So that's the appeal jurisdiction. People can also come direct to the High Court. For example, if somebody who is affected by a law of the Commonwealth wants to challenge its validity, they can come to the High Court and challenge its validity. If that challenge involves contested factual matters, we'll send it to another court first to resolve the facts, and then it'll come back to us.
You mentioned a case of public importance in terms of, you know, a basis for appealing to the High Court.
Yes. What
was the latest one that you've heard in terms of public importance?
We had, there's one, for example, that we've heard where we haven't made a decision, so I won't say very much about it beyond this, that it involves the interesting question in criminal law of a directed verdict of acquittal, where the judge tells the jury they have to bring back a verdict of acquittal. Now, under the law of the state of New South Wales, you can have an appeal to the Court of Appeal of that state from that decision. Now, the state of New South Wales also deals with federal cases, and so they dealt with a federal case, and that law also applied in the federal case. And the question which came before us is where there's a guarantee of trial by jury for federal offences, which there is under our Constitution for indictable offences, is an appeal against a directed verdict of acquittal an infringement of that guarantee of trial by jury? Should the jury's verdict be regarded as final, even though the judge told them what to do? Right. So that's one interesting case that we had. Other cases have involved questions of, for example, fairness and due process in state courts. I mean, I could go on because there's a whole raft of different. Every case seems to be terribly important. Right. And nowadays, yeah, there seems to be a lot of trend in terms of going straight to to the High Court or the Supreme Court, at least here from the United States. Well, the most important direct case that we had was when a man. We had this, of course, like you, affected by the global financial crisis, and the government decided to send everybody a cheque. $900 or $250, go out and buy a plasma television and boost the economy. And there was a legal academic who said, I don't want to get this cheque, and I think the Commonwealth Parliament doesn't have power to spend money that way. So he brought in his own name, a challenge to the constitutional validity of that Tax Bonus Act, as it was called, part of a fiscal stimulus package. And we ended up upholding the validity of it, but in the course of it, some of the points that he made were also upheld by the court. So it became a very important constitutional decision, and one brought by an individual in his own name in the original jurisdiction of the court. And all the state governments were represented, and the Commonwealth was represented, so it was bigger than Ben-Hur, as they say. I was going to say, that must have been a massive case, and you must have had a packed courtroom. It was indeed, yes. Yes, that's right. Let me switch a little bit in terms of the family. I know that your wife is also a judge. Yeah, she's a retired judge. She's a retired judge last year. And your sons, your kids, are all practicing lawyers. No, two of them are lawyers. One of them's seen the light and gone into information systems and accountancy. That's actually pretty good. He'll probably make a lot of money doing that, right? He'll probably do better than the lawyers.